So I'm not sure if it's document or this.
Real life, sir.
Okay, nice. So hello everyone from all parts of the globe. In case you're joining us and listening on YouTube, we have today Professor David Collins from the City Law School, and welcome to another edition of the CADR lecture series. It's about the ICSID rules today, and we are going to discuss about the updates in the recent updates in ICSID rule. And we have Professor Collins explaining that to us. You may have read about Professor Collins, but I would invite Professor Collins and request him to share more about himself and certain things which are not available online or over the web about Professor Collins. Over to you, Professor Collins.
Okay, thank you very much. And thanks so much for having me today to speak to your students. It's a real honor. So I do appreciate that. So my name is David Collins, and I teach international economic law at City University of London. And I've done that for a good while now. And my specialties are the World Trade Organization and international investment law. So I look at investment arbitration, but also the contents of investment treaties. Last few years, I've done a lot of work on the UK's free trade agreements since it left the EU and some of the issues arising from those agreements, specifically in relation to digital trade, which is an area that I've developed expertise in the last few years. I'm from Canada originally. I practiced briefly in Canada, but I've been an academic full-time for most of my career here in the UK. So, as indicated, today I'm going to talk to you about recent reforms to ICSID dispute settlement rules. And as you may know, these came about in the last summer of 22, and there's been a little bit of discussion about them. So I want to look at some of these changes and just flag what might be some of the issues that might arise in the context of these changes. But before we do that, I think it's really important to give the context of ICSID and the broader context of investor-state dispute settlement, which, as you probably know, is very controversial for a number of reasons, some of which are procedural in nature, sort of narrowly technically controversial. And in other respects, it's controversial for much broader reasons in relation to illegitimacy of the whole concept of having international tribunals resolving sovereign disputes. But I don't want to get into that into too much detail because the main focus will be technical today. So let's introduce ICSID as an organization, and I'm sure many of you are quite familiar with ICSID. So the ICSID Convention came out in 1966, also known as the Washington Convention, and it provides for arbitration, which we now know as investor-state dispute settlement, or if you're in the industry, you might know the abbreviation ISDS, and also conciliation between host states, that is the countries that receive the investment, and the foreign investors. So this is mixed arbitration, classic mixed arbitration. One party is always a state, and the other party is always an investor, a company. It's important to recognize also, and I think maybe we've kind of forgotten this over the years, that ICSID was created by the World Bank. It is part of the World Bank. And as you may know, the World Bank was a creation of the Bretton Woods organizations in the 1940s as a tool of international economic development. So the World Bank is a development agency. That is to say that it is designed to increase the prosperity of poorer countries. And the link between that and investment is sometimes forgotten. And the idea behind ICSID, of course, was that if investors felt safe investing in the developing world, they would be more likely to do so. And then that would lead to prosperity, would lead to capital flows into those countries as an alternative to aid. So in that sense, ICSID was created as a developmental tool, as a developmental instrument. And I think maybe we've kind of forgotten that in the last 20 years or so, because the use of ICSID has become incredibly popular over the last 20 years, which is really, I guess, the time period when I've started teaching this material. throughout the 21st century, it went from being something quite obscure to being a very mainstream aspect of what you might call business law or international commercial law generally. Use of ICSID as a system of procedural rules governing investor-state dispute settlement has become very popular over the last 20 years. And we now have a growing body of what you might call case law. Now, if you know arbitration, you know arbitration, of course, is only for the parties. It's not like court. It doesn't have precedent. It doesn't really create jurisprudence as we understand it in the system. But there are cases are cited in other cases. And in that sense, we have a growing body of understanding of how it works. And importantly for our purposes today, this includes procedural rules. So not just the substantive rules, for example, what is an expropriation or what does expropriation mean, but also procedurally how are claims brought? What is the way in which claims are brought through this procedure? What are the rules governing the ways that the claims are brought and defended? One quick statement, and then I'll drop it, but I must say ISDS, investor-state dispute settlement generally, has been severely criticized as an affront to regulatory sovereignty, especially from the academic community. It's seen as a way of usurping the role of domestic courts and with severe constitutional implications and so on. I'm sure most of you watching this know this. I won't go into that because it's not entirely relevant to our purposes today, but I want you to think about it sort of sitting there in the background. I want you to think about the reforms we're going to discuss in the context of maybe a broader sense of discomfort that people have with investor-state dispute settlement. And ICSID, I think, very much trying to demonstrate that it is mindful of these concerns and is progressive and reform-minded. So with that in mind, many reform initiatives have been proposed for ISDS, notably by UNCITRAL, the branch of the United Nations. UNCITRAL Working Group 3 has done a lot of work in the last few years, and also by ICSID itself, and that's what we're looking at today. So ICSID updated its rules in 2022 after about 5 years of consultations, and this is the fourth time that the rules have been revised since 1960. So moving on, we're still not quite ready to look at the reforms because I do want to give a bit more background to ICSID. Just for the sake of completeness, I think we've got students and audience members at different levels of awareness. So I think completing the picture is necessary to get a sense of the importance of the reforms. So who are the ICSID members? How big, how significant is this organization? And this map gives you a pretty good indication. The dark blue are the contracting states. And I think you can see fairly obviously that this is most countries in the world. Most countries in the world signed on to the ICSID Convention, which means they recognize that ICSID is a system of procedural rules that they're in theory prepared to accept. And this doesn't mean that they consent to every arbitration. We'll come to that in a minute, but it means that they consent to recognizing the outcomes of ICSID as being binding. I'm aware of my audience. I'm speaking to a law school in India, and you can see quite noticeably on that map, there's good old India, and it's gray because India has not has not ratified the ICSID Convention, nor has it signed it. Other holdouts include Brazil and South Africa. States have been reluctant to join on, and even Russia, which has signed the ICSID Convention, has not ratified it. And as you may know, if you're a student of international law, the difference between contracting and signing: contracting means you agree to be bound. Signing means you don't necessarily agree to be bound, but you promise to make a good faith effort not to act in a way that's inconsistent with the treaty. So that means that Russia is kind of agreeing to it. And I just want to add, I mentioned a minute ago, I'm from Canada. Canada only recently signed on to the ICSID Convention. And a number of South American countries joined and then left. South America has always been a bit apprehensive about ICSID. But generally speaking, we have broad membership of the ICSID Convention. And this map is as of June 30th, 2022. Once again, I urge you just to keep in mind, remember, ICSID was designed as a developmental agency. So you might expect it to have seen a broad accession from developing countries, which it does more or less. So just a little bit more about ICSID. So jurisdiction of ICSID extends to any legal dispute arising directly out of an investment between a state party and a national of a state party. Three issues there for lawyers. First of all, what is a legal dispute? Secondly, what is an investment? And third, what is a national? Those are three legal questions, none of which are resolved by the ICSID Convention. Legal dispute, perhaps the hardest one to put into words, but I think we have a sense that it means a non-diplomatic dispute. ICSID is meant to depoliticize, to take the diplomatic tension out of disputes and crystallize them into formally legal ones. Investment. Boy, there's been a lot of cases on this, a lot of articles, academic commentary. What is an investment? What is the kind of commercial activity that ICSID covers? Again, the convention is silent on this. If you want the answer to what an investment is, you've got to look at the relevant investment treaty under which the name is brought. That's another topic today. And again, the question of nationality, what is a national? Well, that's determined by the state law of the home state. What does it mean to be a British company, to be an Indian company, to be a Canadian company? We've got to look at Canadian corporate law, Indian company law, British company law for those answers. You won't get it in ICSID. So, as we know with arbitration, investor-state dispute settlement is a kind of arbitration very much modeled on commercial arbitration. And because it's arbitration, that means that it is consent-based. Parties must give consent to ICSID to resolve their dispute, and they must do this in writing. Have to give your consent in writing, and once you've given your consent to ICSID to resolve the dispute, you cannot withdraw it. So you're stuck in that path, and this is meant to crystallize the dispute, narrow the focus, and involve this sort of litigation on multiple fronts. Consent is typically extended in one of the following: an investment contract. So, for example, let's say a Canadian mining company signs a contract with the government of Botswana. You have government of Botswana as one party to the contract, and the mining company is the other party. And Botswana in that says we consent to ICSID arbitration. Fairly straightforward. We'll come back to investment contracts in a minute. National investment legislation. Sticking with Canada again, the Investment Canada Act broadly refers to ICSID as a form for which Canada is willing to have disputes brought, or an investment treaty. The UK-India Free Trade Agreement investment chapter might specify ICSID. By the way, as you probably know, that treaty doesn't exist yet, but we're hoping that it will do shortly. And it will likely refer to ICSID in the investment chapter. We also know that ICSID is self-enforcing, and this is what probably makes it the most attractive of all of the ISDS systems. You don't need an additional enforcement procedure. If you have an ICSID judgment, it is as good as a final judgment of the highest court in any ICSID member state. It's like an Australian High Court judgment, a UK Supreme Court judgment, a US Supreme Court judgment. You don't need a separate procedure, which you might, for example, if you use UNCITRAL, and that's a major advantage to companies using ICSID. Last point I want to make on an overview, because I don't want to spend too much time on this because we want to turn to the reforms. There's no appeal from an ICSID decision. ICSID rulings are final, and that's also seen to be an advantage because it provides finality and closure, shortens the time frame, and so on. However, as you probably know, there is a narrow annulment procedure, which is only for procedural irregularity. So it's not for mistakes of law, it's for mistakes or errors of procedure, such as failure to give reasons, improperly constituted tribunal, and so on. Very narrow grounds. Tends to be used a lot, but in some cases inappropriately. but it is a very narrow procedure. And onto the arbitration itself. How does the arbitration work at ICSID? Very briefly, ICSID maintains a panel of arbitrators to help with party selection of the arbitrators. So this is the ICSID roster, and there's currently 687 people on the list. They tend to be nominated by ICSID member states. Britain nominated some people to the roster a few years ago. And I can tell you right now who's not on it. I'm not on it. I would like to be on it. I wanted the British government or the Canadian government to nominate me, and they never did. There's some prestige of being nominated. We have 87 indicative people who can be chosen as arbitrators. When arbitrators are chosen, it has to be an uneven number, fairly obviously, because you need a tiebreaker to get an outcome. 1, 3, or 5. The default is 3. It's usually 3. There have been a few cases with 1. 5 would be very rare. To be an ICSID arbitrator, there are certain qualifications, and these include high moral character, recognized competence in law, commerce, or industry, and perhaps most importantly of all, the ability to exercise independent judgment. There are many, many controversies about the arbitrators for ICSID, and this would be a separate talk in itself. There's major allegations of illegitimacy because of repeat appointments, the fact that it tends to be the same people over and over again, which you may or may not like. There's allegations of bias, often in relation to double hatting. That's people that have appeared as counsel in a similar dispute and then as arbitrator in a related dispute, suggesting there's bias. Delay, meaning that they take too long. Expense, they charge too much, and so on. You could add to that the allegation of gender discrimination because they're mostly men. You could say that there's nationality discrimination because they're mostly from Western countries. There's a litany of complaints that you can make. And I'm not saying that any of them are valid. I'm just pointing out to you that these controversies are there. And as a consequence, ICSID, together with UNCITRAL, created a draft code of conduct for arbitrators to deal with some of these issues a few years ago. And that's not reflected in the 2022 update. And I won't be talking about that anymore, but feel free to have a look at that if you're interested in that, these identity issues about who precisely the arbitrators are and why they're not picking British academics from Canada to be arbitrators. The ICSID caseload, just to give you a snapshot of the popularity of the tribunal before we get into the films. There have been 910 total cases registered under ICSID since its first case in 1972. And if you look at that chart running from 72 to 22 across the bottom, I think we see a fairly obvious trend, and that trend is an increase in the number of cases per year, starting around the year 2000 or the late 1990s. Dips here and there, big increase in 21, drop in 22. Maybe that was because of COVID. Have we seen a peak of ICSID? Will it continue to grow? I suspect we may have seen a peak or we're nearing a peak. And I think that is largely due to the fact that ICSID is no longer ISDS is no longer a popular sphere of dispute settlement because of the controversies. The light has just gone off in my office, so I hope I'm not too dark for everybody. Too much light. So again, I would say there's a rising trend of increase in popularity in the case over the years, but maybe that's tapering off. I want to also mention to you the sector of ICSID cases. This is a 2-year snapshot from a couple of years ago. Just to give you a sense of the importance of ICSID, it's covering basically all sectors. It's not a mining extractive sector tribunal. It's not a utilities tribunal, as you may have heard, or you may have felt through the media. It really is covering all sectors. Now, oil, gas, and mining are 22%. Electric power and other energy, sort of energy you might call utilities, they're a quarter, 24%. And then we see a pretty even split across other sectors, including, interestingly, finance, transportation, tourism. So there are definitely services, information, and communication. So although it would seem as though oil, gas, and mining have been dominant historically, I don't think by any means it's fair to say that they have been the only game in town in the sectors that exist. So a broad sector of coverage for ICSID cases. And I think that perhaps is a reflection of the competence of the tribunal and the procedural rules to adapt to disputes coming from different sectors. Basis of consent. I want to put this slide up because I mentioned consent a minute ago. So you know that you have to consent to ICSID arbitration because it is arbitration. And it's consequently, it's based on consent, and the consent must be in writing. And in the last couple of years, this is a snapshot for the last few years. Here are the documents, the source documents through which consent has been granted. And the biggest, I would say by a significant margin, 56%, are BITs, the classic bilateral investment treaty, like the UK Singapore BIT, for example. 56% of all disputes have come through BITs. Interestingly, the second most significant, and this is a change from recent years, are investment contracts. Investment contracts between the investor and the host state. So as I said, for example, a mining company signing a contract with South Africa or something. So that was much smaller a few years ago, went from sort of 7, 8, 9, 10%. And I think there's an indication that that will grow and grow, and the investment contracts will become more relevant. The Energy Charter Treaty is the single most important instrument for grounding ICSID claims. And as you probably know about the Energy Charter Treaty, 11% there, Energy Charter Treaty is being slowly abandoned by European Union member states, a number of countries, Poland, and I believe France, possibly Germany, and one or two others have pulled out recently due to climate issues. So Energy Charter Treaty is poised to decline. And then we've got NAFTA and its forerunner, the US, and its follow-on agreement, which is the USMCA. NAFTA and the USMCA, roughly 4%. Investment law of the whole state, and one or two other relevant free trade agreements. I noticed that the Dominican Republic US free trade agreement had a few disputes brought on it. So again, fairly broad church in terms of where the consent is coming from, but the BITs are the dominant ones still. And then outcomes. I don't want to spend a lot of time on this. I could, and I'm not here to espouse a particular view, but I just want to flag this issue because I'm sure some of you are aware of this. We know there's a backlash against investor-state dispute settlement and against ICSID, probably particularly against ICSID. And one of the reasons that we have this is the widespread perception that ICSID is biased against states and that the investors usually win, that it's sort of weighed in favor of the big corporations. If you look at this slide, which is referencing outcomes from the last couple of years, you do not see that trend borne out in the outcomes. What you see here is 23% being discontinued, both parties, 14 at one party, 9% discontinued for other procedural reasons, settlement agreement 2%. But if you look at the left-hand side of the pie wheel, you see award upholding the claims in full at 25%. Dismissing claims and declining jurisdiction and deciding without merit 14, 11, and 2, comprising variously 26%. So you're basically seeing of the cases that are not settled or abandoned, half are being won by the states and half are being won by the investors. I see that as being not indicative of a pro-investor bias. I don't see a smoking gun there. I see more or less even outcomes between states and investors. To me, it is not borne out in the data that ICSID is pro-investor. I just don't see that on the data. You may disagree, you may have your own views about that, but I just want to flag that as something I think needs to be said. Okay, so that was enough of my sort of background. Now let's look on to the ICSID reforms. I'm going to go through a few of them in the next sort of 10 slides. So first of all, 2022 ICSID reforms in relation to third-party funding. So you may know that third-party funding has been a bit controversial, and this is based on the old common law concept of champerty, which was this aversion to having someone funding someone else's litigation, because it was sort of seen to make litigation or the use of courts as a sport. And there was something seen to be a bit unethical about that. That has a deep history in the common law, and it's borne out in arbitration. And there was this perception, and I think maybe there was some truth to it, that some dark forces were quietly profiting from ICSID arbitration. They were picking companies or picking states, much like you might pick a horse or a football or a cricket team, and they were funding them because they thought they would win and then they were going to get a chunk of the payout. And there's something that seems a bit unethical about that. So under Rule 14, there is now a notice of third-party funding upon registration. Parties must disclose the name and address of the funder and anyone who owns or controls it. So it doesn't prohibit third-party funding. All it does is it makes parties disclose who the funder is. Great, maybe from an ethical perspective. Some of the complaints, some of the controversies about this that I've come across, there's a concern that third-party funding as a concept is not properly defined. In particular, people are not quite sure whether this covers contingency fees, sort of only get paid if you win, for example. There's a concern that this could adversely affect a party's procedural strategy. Access to finance throughout a procedure might make them not able to bring the claims that they want to or request the evidence that they want because they're not certain about whether or not the publicity could affect their revenue stream to source the dispute. There's concern that this could end up compelling the disclosure of certain arguments earlier than they have been wanted by the party. So, for example, if your funder maybe is, an energy company, maybe you're going to be making a claim in relation to the price of energy being an element of expropriation. And now the state is going to know that in advance, and they'll be able to prepare for that in a way that they wouldn't have otherwise. So it'll sort of game the strategy. It could also affect the arbitrator's view of the case. Maybe if an energy company is funding the litigation, maybe that arbitrator doesn't like energy companies. Maybe they were dismissed by an energy company. Maybe their wife's brother works for an energy company and they don't like the guy and there's personal resentment. You can imagine all kinds of scenarios that could play into this. So there's a concern that this is perhaps undermining some of the confidentiality that is so central to arbitration historically. Okay, so on with reforms about reductions in time and cost. So one of the classic complaints about ISDS and ICSID is that it's too expensive and it takes too long. And this is ironic because we've always said about arbitration that it's preferable to litigation because it's cheaper and it's faster. And if you look at any textbook, why do parties choose arbitration instead of going through the court system? You're going to get them. Those as your first two answers, cheap and fast. And over the years, the understanding has been, and I think there's data on this, it probably proves the accuracy of it. Investor-state dispute settlement has become more expensive and slower to the point that it's not clear that it's actually any cheaper or faster than litigation. So ICSID, I think, is really trying to sell itself by saying, no, we are cheaper, we are faster, and they're partly doing this by Rule 3. Rule 3 says as a general duty on the tribunal and the parties to conduct proceedings in good faith and in an expeditious and cost-effective manner. So it's saying basically, you've got to do this quickly and cheaply. You can't waste money. Part of this is now an availability commitment from arbitrators on a 2-year calendar. Now, I do know something about this because I'm on the roster of arbitrators for the trade remedies chapter of NAFTA USMCA. and I've never been an arbitrator, but I can tell you that they've asked me many times for my availability. And you have to block out your calendar 2 years in advance, which means you can't agree to be an arbitrator and then suddenly say, oh, actually, I need a break because I'm going on holiday, or I need a break because I'm writing a book. Apparently, this has happened, and this has slowed down ICSID procedures, and this is saying you can't do that anymore. You need to promise that you're free. New provisions on regular case management for conferences. Case management conferences, which is ways of expediting the procedure. That's Rule 31. Consolidation of light cases and coordination of related cases. That's Rule 46. And encouraging proactivity of arbitrators and parties. Parties, I can see, encouraging proactivity of arbitrators. That maybe seems not quite in the spirit of the adversarial system as I know it from the common law, but remember, this is not court procedures. This isn't supposed to be really courts. Maybe the arbitrators should be more proactive in saying, what's the point? Get to your point. What is your evidence? Why are you presenting this? Rather than letting it sort of drag on. All documents will be filed electronically, and we know that saves time. If for no other reason, you don't have to wait for something to be sent in the post, which could be traveling across the world. And in this country, I don't know about India, but the Royal Mail is always on strike, so it delays things. Parties have the option of holding any procedures remotely online. We know that's advantageous. Obviously, I'm speaking to you now in the UK, talking in India, so there's no reason why this couldn't be an ICSID. Why not? It saves time and money. I don't have to pay my airfare. Concern that this could end up rushing proceedings and adversely affect quality. So as with any of these efficiency objectives, what do you sacrifice? Potentially you sacrifice quality and legitimacy of outcomes. We want the right outcomes, we want good law, and maybe by rushing things, we're going to undermine them. Okay, so now we have some interesting issues about reforms relating to reductions in time and cost. And here we see this in Rule 58. So again, about getting things going, getting expediency. 58.1, the tribunal shall render the award as soon as possible, and in any event, no later than 60 days after the later of the tribunal's constitution or the last submission, if the award is rendered pursuant to Rule 41.3. Which is where it's manifestly without merit. 130 days after the last submission of the award is rendered pursuant to Rule 44.3c, which is also about lacking prima facie strength, or 240 days after the last submission in all other cases. This is roughly speaking a third shorter than the old regime. So we're shrinking the time frames, getting the award out faster. And also Rule 58 specifies that a statement of cost and submission of costs filed pursuant to this rule shall not be considered a submission for the purposes of this paragraph. So what this is basically saying is statements regarding costs do not trigger an extension of the time frame. So the time frame is still running even if a cost submission comes in the procedure. It doesn't start the clock. Narrowing the time frames. So once again, you might say, great, you're getting a faster result, you're getting a cheaper result, but we have a concern that this could end up rushing the proceedings and diminish the quality of the judgment. And if we really care about quality of the awards, legal legitimacy, legal accuracy, then maybe there's some concern that this is too rushed. And I think some practitioners have hinted at that. Then we have Rule 52 on costs. So again, one of the classic criticisms of ICSID, and I've said this already, but it bears repeating, is that it's too expensive. And I think, once again, it's ironic because ISDS and ICSID have always been presented as cheaper alternatives to litigation. And I think that's generally seen as being one of the advantages of commercial arbitration. Yet over the years, the cost of ISDS ICSID hearings has gone up. And there have been some famous awards. If you look at the UCOS award, which has been in the billions of dollars, and the costs have gone up proportionally. You can get data on this, but you can see costs in the hundreds of millions of dollars. So there's a big question mark as to whether or not these proceedings are actually cheaper than the alternative, which would be domestic litigation in whatever state court. So we now have Rule 52 on costs, and it says, in allocating the cost of the proceeding, the tribunal shall consider all relevant circumstances. So the tribunal say it has the power to allocate costs to the winner, to the loser, or proportion of the two, including the following outcomes, the following matters: the outcome of the proceeding or any party to it, or any part of it. So maybe who's won or who's lost. The conduct of the parties during the proceeding, including the extent to which they are acting in an expeditious and cost-effective manner, and complied with the rules, and followed through on the orders and decisions of the tribunal. So basically, if one of the parties is being difficult, not responding to emails, waffling, taking too much time, and it's evident that they're not behaving in a good faith manner, then they can have costs awarded against them. The complexity of the issues. Maybe if the issue is particularly complex, maybe the costs should be high. If the issue isn't that complex and it's being made to look like it is, maybe the costs are too high and then the other party should be forced to pay them. And this is linked to D, which is the reasonableness of a cost claim. And as any law student will know, whenever you see reasonableness, this means that we have a high degree of discretion according to the decision maker, in this case, the tribunal. So if the tribunal renders award pursuant to 41.3, this means that the claim is manifestly without merit. It shall award the prevailing party, the winning party, its reasonable costs, unless the tribunal determines that there are special circumstances that justify the cost. If the claim is without merit, you're not going to get your costs. The other side will. Why did you waste their time? The tribunal may make an interim decision on costs at any time on its own initiative or on the party's request. And the tribunal shall assure that all decisions on cost and reason are form part of the award. And this is important because if you get a reasoning about cost that forms part of the award, you have a record about what that tribunal decided. So since you're getting a bit of jurisprudence about cost, and that will help the predictive element of it, it will help the consistency of it. And I think all of that contributes to fairness. Once again, though, just playing devil's advocate, I think we want costs to go down, unless, of course, you're the law firm or you're the arbitrator. But you might wonder, might this emphasis on downward pressure on costs impair the ability to mount the best claim or defense? If your costs are not being awarded, you're worried you're not going to get your costs, maybe you're going to be too nervous to make the claim or the defense that you wanted to, and in some way that's going to impair your rights. So I think that's a really important consideration to make. So again, I pose this sort of rhetorical question: which is more important, the efficiency or the integrity, the efficiency and the accuracy? So I would urge you to think about that. Then in Rule 53, you have the element of security for costs. So what if you have a party bring a claim and they actually can't afford it if they lose and have costs awarded against them? And this may become more relevant as we think about smaller companies bringing claims. I think traditionally we've thought of ICS as being a playground for the big multinational that has deep pockets and can afford the best law firms. But increasingly, and rightly so, I think we're seeing SMEs beginning to bring claims. And SMEs don't have the deep pockets, which is great if you look at the perspective of access. But it's more problematic if you think about strategic arbitration and an investor bringing a claim that they honestly cannot afford to properly defend, particularly if they lose and they have an adverse cost on it. So 53.1, upon request of a party, the tribunal may order any party asserting a claim or counterclaim to provide security for costs. And the following procedures shall apply. The request shall include a statement of the relevant circumstances and the supporting documents. The tribunal shall fix time limits for submissions on the request. And if a party requests security for cost before the constitution of the tribunal, the Secretary General of ICSID shall fix time limits for written submissions on the request so that the tribunal may consider the request promptly upon its constitution. And lastly, the tribunal shall issue its decision on the request for security for costs within 30 days after the later of the constitutional tribunal of the last submission of the request. So we're getting procedural rules about allowing requests for security costs and when this can be done. So not clear to me that I see a problem with this. Maybe someone in the audience does see why this could be problematic. I can only think that this is a good thing. I mean, there's obviously an extra procedural element to it, maybe going to itself cause an expense, but this seems to me to be completely reasonable. Then you're on to the transparency confidentiality agreement. So one of the other classic things that we always say about arbitration, commercial arbitration, but also ISDS, investor state dispute settlement, is that it's good because it's confidential. You don't necessarily want the nature of your problem with the host state to be public knowledge because it could affect your share value. You're upset because there's been an expropriation or an alleged expropriation, and this might attract media attention. The country doesn't want to see it because it makes them look bad. It could affect they're attracting FDI from other sources. So there's been this sort of default confidentiality in arbitration, and that's one of the reasons again why you might prefer it to go to court. But over the last 10 years or so, as part of the backlash against ISDS and the perception of the illegitimacy of it, there's been an emphasis on transparency. And we see this in Rule 63. Publication of orders and decisions. The Center ICSID shall publish orders and decisions with any redactions agreed to by the parties and jointly notified to the Secretary General within 60 days after the order or decision is issued. Wow, default transparency. The default is now that you're going to get all the documents from the, except the pleadings, you're going to get the decisions on the ICSID website. That means it's going to be all over the internet, all over the other databases in a short time frame. However, sub 2, if either party notifies the Secretary General in a 60-day period that the parties disagree on any proposed redactions, the Secretary General shall refer the order and decision to the tribunal to decide any redactions. The Center shall publish the order and decision of the decision of the tribunal. Either party can say no, we don't want it published, or we're agreeing to having it published, but these various bits need to be cut out, maybe because it contains a trade secret or it's something embarrassing or confidential, or something that has a commercial impact. And these have to be, the actions have to be agreed. In deciding a dispute pursuant to paragraph 2, the tribunal shall ensure that publication does not disclose any confidential or protected information as defined in Rule 66, like a patent, like a trade secret, or something like that that could have a commercial application. So to the segment of people who don't like ISDS and who pointed out its illegitimacy, this is music to their ears because this creates a transparency and brings with it legitimacy and all these things that ICSID allegedly lacked over the decades. To maybe the traditionalists, maybe to the users of the system, I think there's a strong claim that this undermines the confidentiality of arbitration. It strikes at the heart of really what arbitration was meant to do, which is to be to provide a private dispute for those parties away from the lights of the court. But it's not absolute. It's a default. The parties don't have to. If one of them doesn't like it, they can get out of it. So I think it's a default. I'm not too massively bothered by this, and I think it shows maybe that ICSID's heart is in the right place in as much as it demonstrates its willingness to recognize that there were transparency concerns from stakeholders. Rule 75, the expedited arbitration rule. So back to the speed issue. 75, sub 1. At any time, the parties to an arbitration conducted under the convention may consent to expedite the arbitration in accordance with this chapter, called the Expedited Arbitration Chapter, by jointly notifying the Secretary General in writing of their consent. So the idea here is, if the parties think it's going too slow, and maybe the dispute isn't as complicated as they thought it was, they can crank it up and get on with it faster. Why keep paying your lawyers' fees and their hotel bills and all this stuff if you can get it done faster? So this is sort of the parties getting together and recognizing that they don't need it to take as long as it does. If an arbitrator is unavailable to proceed on an expedited basis, maybe because they're teaching during the day or they've got marking, which is something that I can identify with, the arbitrator then can offer to resign and say, well, I have a book deadline, or I don't know, it's my daughter's graduation or something, I can't make it. So it's suggested that this could reduce the length of an arbitration by up to 50%. Fantastic, from a cost and savings perspective. It's seen as a way to promote the use of arbitration by SMEs that don't have the money that the big firms do, and they're more cost sensitive. Fantastic. You think SMEs might love this, and they probably would. But you have the same issues about legitimacy and accuracy, quality, and there's a question, maybe this is putting pressure on arbitrators. Maybe the arbitrator is thinking, well, I want to resolve this, but I do have these other obligations, and now I'm being pressured to come up with a ruling, and I'm not maybe thinking it through clearly, or I'm not giving it the attention I should. So there are drawbacks to this. You're getting a saving, but you're having a drawback potentially as well. Here's one of the most interesting ones. Broader access to the additional facility rules. The additional facility rules, historically, ICSID was only available between where one of the parties had a connection to an ICSID signatory. So either an investor from a signatory or a signatory country. So one of the parties had to have a link in some way. The additional facility rules, traditionally it had to be both parties, then it was one party. Now, neither party has to have a link to the ICSID convention. But now, under Article 2 of the additional facility rules, you can have cases involving parties that are not ICSID member states or nationals of such states. So neither party needs a connection, which means you could have a South African company bringing a claim against India. Neither South Africa or India are signatories. So ICSID is really saying we're really opening the doors for business. It's not just one party or one party. And then really interestingly, on Article 2 of the AFR, you can also have ICSID taking jurisdiction over a matter that involves a regional economic integration organization, REIO, which is an acronym you may not have heard of before, but it basically means something like the EU, a supranational organization. In fact, I think it really is about the EU. Although interestingly, I imagine it could potentially include ASEAN or even the CPTPP at some point in the future. This is interesting when you think of all the EU discussion about the Energy Charter Treaty and countries pulling out, member states pulling out, the EU staying on as a signatory. This could become very relevant in the future with REIOs concluding more international investment treaties. As you probably know, the EU now has exclusive competence to conclude investment treaties. So the EU signs the investment agreements with other countries like Japan and Canada. And now the EU could potentially be a respondent state, as it were, under these arrangements. So I think that's a really interesting sort of recognition of the role of these supranational organizations. And I have a feeling it was really done with the EU in mind. So that's interesting. Reforms, continuing, updated fact-finding rules. We're near the end now. I'm getting close to the end, so don't get too impatient. Parties jointly request the fact-finding committee to determine a procedural protocol and to make specific findings of fact in a dispute. As you probably know, if you've looked at investment cases, they're very fact-intensive. In fact, there's more facts in them than there is law, and ICSID takes this element of its jurisdiction seriously. So we see in Rule 2, the Secretariat of ICSID is authorized to administer fact-finding procedures that relate to investment, involve a state or an REIO, and which the parties consent to in writing to submit to the center. So the Secretariat can get involved in finding facts relevant to determine the outcome. And once again, reference to a state or an REIO includes a constituent subdivision of the state, so like France is part of the EU, or an agency of the state or REIO. The state or the REIO must approve the consent of the constituent agency, which is a party to the fact-finding procedure, paragraph 1, unless the state or the REIO concerned notifies the center that no such approval is required. So what this is really doing is it's expanding the jurisdiction of the Secretary to conduct fact-finding, which can be quite relevant, again, because the factual element of these disputes is so determinative. They're really trials, exit cases. They really turn typically more on what has happened rather than the legal concepts. That's my own personal view. They're heavily fact intensive. I think this is a reflection of that power. And the last reform, new mediation rules. New mediation rules complement bilateral and multilateral treaties, notably the Singapore Convention, providing for mediation, and this enhances the enforceability if any resolution is reached. And by that I mean enforceability of a mediated settlement if a resolution is reached. This is available between parties in a dispute relating to an investment under an existing agreement or agreed to the parties on an ad hoc basis. And importantly, under the mediation rules, the new mediation rules, this can be instigated at any stage of the process, including before the arbitration has begun. So mediation is now broadly available with parties' consent. And again, parties don't need to be nationals of a member state or to be a member state of ICSID to make use of ICSID's mediation rules. So it's really expanding the reach of the mediation rules with a view to normalizing the use of mediation as a way of forestalling the intensification of a dispute through arbitration. Okay, so just to conclude very briefly and generally everything that I've said. So overviews and conclusions. The updated ICSID rules reflect an emphasis on efficiency, that's speed and cost reduction, as well as ICSID's responsiveness to what many have called the backlash against ISDS. I think this is ICSID saying that it's listening and it's aware that there's a resentment against that procedure. They expand the availability of ICSID to a wider range of parties, including REIOs and also SMEs by lowering costs, perhaps with a view to keeping ISDS relevant in the 21st century, as ISDS provisions begin to disappear from investment treaties. There is a concern within the arbitral community that the new rules could sacrifice flexibility and undermine the quality of decisions by really pushing that speed and cost reduction ethos. Obviously, the effectiveness of the rules will depend on their application in practice, and we'll begin to see that in the coming years. And as a very broad overview, and I think I've hinted at this, I see these reforms as being ICSID, again, demonstrating its responsiveness, demonstrating its awareness of the dissatisfaction with ISDS, some of the perceived problems in relation to illegitimacy, cost and expense. And I see really ICSID fighting for market share of a shrinking industry, which is the ISDS industry. As ISDS disappears from investment treaties, I think you're going to start to see a decline in the number of investor state dispute settlement cases. And this reminds me of that old advertisement, and I forget which tobacco company it was. And the advertisement was something along the lines of, if you smoke, please try X brand. And I think ICSID is saying, we're not saying that ISDS is a good thing. Maybe it's bad. Maybe there's something wrong with it. Maybe you should be using domestic courts. But if you're going to use ISDS, you should use ICSID instead of something else, such as UNCITRAL or other ad hoc system. So I think it's ICSID really saying, look, we're trying to stay relevant. We recognize there's an issue. and we're hoping that this is solving the needs of our users. And with that, I will conclude, and thank you very much for your attention.
Thank you very much, Professor, for putting it down so concisely and in, in a nutshell. I think we haven't received any questions as yet, but if you allow, I just had a quick, I would want to have a quick thought probably run through you. And then that's largely on gender discrimination under investment arbitrations, because we have seen organizations such as the Racial Equality for Arbitration Lawyers, REAL, come up in the recent past, and given the reach of ICSID as you showed it from the map, it's across the globe. How do you see, and what, and largely in your opinion, how do you think the ICSID can take care of gender discrimination per se?
Well, that's a good point. I think one of the ways it can be done, I see this as indicative as gender discrimination in many contexts. And I wonder, is ICSID the right form to address it? Is not the issue, not that not enough women are being appointed to be ICSID arbitrators, but there aren't enough females in the system, the legal profession, the senior legal profession, the arbitration profession, from which to draw upon. So I would suggest that maybe the problem should be brought to an earlier stage in the process. And if we start to see more females going to university, going to law school, getting into commercial law, and instead of, I have to say, instead of things like family law, for example, which tends to be the trend in this country, maybe there'll be a larger pool of women to draw from. I've seen initiatives taken by the LCIA, the London Court of International Arbitration, of which I used to be a young member. Now I'm just an ordinary member. And there was events for women, getting young women to think about arbitration. So I think those are great initiatives. I'm personally against any kind of a quota. If ICSID said you have to have a female arbitrator on every panel, I wouldn't like that. I personally think that would be demeaning to women, and I don't like quotas. I think you've got to have the best arbitrators. But if you get a larger pool of females from which to draw from, they're going to get chosen. And I should point out the number one ICSID arbitrator who has appeared in the most cases is a female, Brigitte Stewart. So we know women can do it. Just a question of getting them primed so that they have the expertise to get those appointments.
I think we just have received another question. I just won't take more time. The last one, I guess, as Suhasini asks, as one of the major changes brought by the new rules concerns the express regulations of third-party funding, but don't you think that the broad language used in recent arbitration rules makes it hard to know exactly when something qualifies as TPF or not? And will that be how will that be determined?
I completely agree, and I think that comment or question is entirely on point, and I think it's a reflection. Look, in any instrument, we're going to have an inherent ambiguity of rules that the parties will seize on. This is what lawyers do. They're paid to find ambiguities. And I think this question has identified one of them. What would have been helpful was a more detailed layout of precisely what third-party funding meant. But I think that would have been very difficult for the ICSID parties to bring through, because it would have required more negotiation, it would have required more specificity. And I think it probably would have required an understanding of the financialization of various vehicles that maybe is outside the expertise of an ICSID tribunal. It's really about financing. So it's about packaging resources. Is it going to be a listed company, a partnership, a limited partnership? Does it have to have a certain level of capitalization? So there's all kinds of different financial instruments that could potentially escape the definition depending on how they're structured. So I think that question is absolutely right. This is going to be challenged, and I would hope that the discretionary element that's retained by the arbitrators will win the day, and the concept of reasonableness will tide us over until we have a bit more certainty.
Thank you, Professor. I think we have the last question from Gautam. Gautam basically wants to know if you could explain the important recent reforms to ISDS as a whole, apart from ICSID reforms. Sorry, it wasn't Gautam. Gautam's question was, how do the new ICSID rules address concerns regarding the legitimacy of investment arbitration?
So that's the big question. And we have the UNCITRAL working group, 3 reforms that have looked at substantive issues. And I think they're along the same lines. One of the reforms that's underway is the obviously we have the emphasis on transparency, and that was an achievement of the Mauritius Convention from a few years ago. I think that goes a long way. We have the code of conduct from arbitrators to get this sense of the impartiality. I think that's taking it along as well. And now we're seeing the ICSID rules addressing some of the other issues about costs and efficiency. The bigger issue, the really quintessential issue, is the one about sovereignty and the ISDS as a process undermining the sovereignty of domestic courts. And the response that I've always given to that is, well, if you have consent from the signatory state, from the country, then you don't have a sovereignty issue. So I think you have fundamental issues about the investment treaties and whether or not they're generally consent based. But on the ISDS front, the issue comes down to exhaustion of local remedies. I think that's got to be the equilibrium point. If you have a requirement to exhaust local remedies with a reasonable time frame, and if I'm not mistaken, I think this featured in the UNCITRAL discussions. I'm not entirely sure that it was adopted. If you have an exhaustion of local remedies period, a modest period, let's say 6 months to a year, where you're required to use the host state courts, and if that is dysfunctional and you do not have your hearing and you don't get a day in court, then ISDS is engaged. I think that's the best of both worlds, because you're seeing a recognition of the sovereignty of the host state's courts as being primary, and then you're seeing ISDS able to step in when that's failed. And I honestly can't see how anyone could seriously advocate against that.
I think we don't have any more questions, Professor. We are really, really grateful to you for taking your time, and specifically on a Friday, and hope you get more and more of the sun this season. Thank you for your time today.
Okay, thank you very much. I really appreciate everyone, and thanks for paying attention. And have a nice weekend, everybody.
So to you, Professor. Thank you so much.
Bye.
Bye.